Jen the Liberty Lion. And today, this book is a book that I ordered a couple weeks ago. I just opened it up and started reading it this evening. And I'm not sure why I bought this book. I guess I don't know if it just looked good or if it was a footnote. But anyway, here we are. And I found the first couple of pages, interestingly, saying pretty much the stuff that I've said in the last couple of videos. It's called Philosophical Jurisdiction, Authority, Ultimacy, and the Conditions of Meaning by S.C. Salis. I don't know who this guy is. As far as I know, I've never heard of him before, or at least as far as I remember. So I don't know what he's about, but the first couple things he wrote are interesting. And he says, the meaning of philosophical jurisdiction. So this is a book on philosophical jurisdiction. Philo is love. Sophie is wisdom. So he's talking about, I guess, the love of wisdom and the jurisdiction of wisdom. And I don't think he's talking literally about wisdom, even though he says jurisdiction's not used in his book as a metaphor. I'll have to finish reading it to really understand what he's saying, but I did want to look at the first couple of pages with you all. So he says, every serious inquiry presupposes an authority by which judgments are made. So I think what he means by that is that judges are automatically assumed to have jurisdiction, or a police officer is automatically assumed to have some sort of authority. I think that's what he might be saying here. That authority may be named or concealed, acknowledged or denied, but it is never absent. So either you have authority or you don't have authority. And if you don't have authority, then you don't have it. Where it is concealed, it does not disappear, it merely governs without confession. So it governs without the need to go around touting itself. It doesn't need to wear a uniform and a gun and all those sorts of things. It just is there, sort of like nature. Uh, we don't need the law of gravity to scream at us that it has authority. We already know it does, because when we jump up, we automatically come back down. This book concerns authority. The term jurisdiction is therefore not introduced as a metaphor, nor borrowed loosely from law or politics, nor employed rhetorically to suggest power or control. See, rhetorically to suggest power or control. It is used in a strict philosophical sense, and it must be defined before anything else can responsibly be said. So when he says that it's not metaphor or some loose meaning or rhetorical suggesting control, that also means that he's contradicting those jurisdictions or claims of jurisdiction who do those things. They use metaphor, loose definitions defined in law and politics, or persuasive speech to suggest that they have control that they don't actually have. So he's saying he's not using jurisdiction in those senses. He says in this work, jurisdiction refers to the legitimate authority by which a claim determines how judgments are made, what standards of evaluation apply, and where appeal properly ends with a given field of meaning. So, proper legitimate authority comes from judgments or judges who actually have the authority to make those judgments, where the proper standards are applied and where there is the opportunity to appeal. Jurisdiction names the right to govern judgment, not the ability to compel agreement, to compel contract, to persuade, to coerce, to suggest, not contractual. It is real legitimate authority. It's positive. It concerns legitimacy rather than effectiveness, authority rather than influence. And what do I call the cops? Salesmen. Okay, why? Because they're out there trying to, um, let's see the words he used, suggest power or control, to persuade, to coerce, to compel. That's what the cops do. That's why I call them salesmen, policy salesmen, to get you to sign a contract, to sign their paper so they can get you into their court that has no actual authority. A claim may persuade without possessing jurisdiction, swayed you to come in, to sign their contract and to come in because your signature is an agreement and it gives them a type of jurisdiction, contractual jurisdiction. It may succeed socially, function pragmatically, or dominate institutionally while lacking the right to judge. So you sign the ticket and you've given them the right to judge. You don't sign the ticket and they don't have the right to judge. I can tell you that when I choose not to sign a ticket and I don't sign it, not only do the police threaten me, but eventually they let me go, and the judges never acknowledge any paperwork on me. And so there's never a case and there's never a cause and there's never a citation to come into court for the court to hear, because there was no agreement made between me and their salesman to come to the court. Jurisdiction is not measured by outcomes, consensus, or force. It is measured by whether the authority exercised rightly belongs to the domain in which judgment is being made. So he's saying jurisdiction is not measured by guilt or not guilt, or whether they had to use force against you. It's measured by whether the authority exercised rightly belongs to that court. And then once they have the signature, supposedly it belongs to them because you agreed. This distinction is decisive. Many of the most persistent confusions in philosophy arise not from faulty reasoning, but from unexamined jurisdictional assumptions. They assume, or we assume, that they have jurisdiction, so we don't question it. They look like they have jurisdiction. They wear robes and uniforms, carry guns. They have courts, or what appears to be like courts. They issue papers and they make you sign them. They follow codes and write opinions. Arguments fail not because premises are incoherent, but because the right by which those premises are evaluated has never been agreed or even named. This agreement persists because rival courts of appeal are operating simultaneously, each unacknowledged by the other. Jurisdiction is therefore prior to argument. So I think he's saying that question of jurisdiction is prior to argument, but subject matter jurisdiction can be argued anytime. It governs not what is concluded, but how conclusions are assessed in the first place. It sets the conditions under which evidence counts, reasons persuade, and objections are heard. To dispute conclusions while leaving jurisdiction unexamined is to argue endlessly without ever reaching the real point of conflict. The term philosophical jurisdiction is used here to indicate the level at which this inquiry operates. It does not denote a school of philosophy, a method, or a discipline alongside others. It names a question that stands prior to method, prior to epistemology, and prior to application. Philosophical jurisdiction asks not what is true, but by what right anything claims the authority to say what counts as true, meaningful, rational, or justified. So, for example, these municipalities, sheriff's departments, police, constables, they issue tickets, but there's no crime. There's no actual crime. And an act without a victim is not a crime, but yet they call it a crime. The question is unavoidable. Any attempt to evade it already answers it implicitly. So if you're avoiding the question, why won't you answer it? So if I put in a motion to dismiss for lack of subject matter jurisdiction, why do you just ignore it? You've already answered that you don't have jurisdiction by not answering the fact that I've asked you to excuse the case or dismiss the case based on not having jurisdiction. So you didn't dismiss the case for lack of subject matter jurisdiction, but you didn't prove that you had it. You ignored it. So they evaded my papers because they don't have jurisdiction. Otherwise, they would have shown me how they do. Claims to neutrality, proceduralism, or methodological restraint do not suspend jurisdiction. They merely relocate it. To say that one will follow the evidence or trust reason or let the method decide is already to have granted authority to something and therefore to have entered a jurisdictional posture, whether acknowledged or not. Okay, so I'm not going to read the rest of this. I may read some more at a later time and publish it as a video, but I don't want to do too many pages of this at once because it is copyrighted. It kind of goes along with uh, some of the other things I've been talking about in the last couple of videos about how they don't have jurisdiction, so they need you to contract with them, which means you have to sign something. If you don't want to sign it, they use persuasion, um, coercion, extortion, um, power, control, the fact that they look like they have authority. They use all these things to try to get you to sign their papers, come into their court, and then they make you pay them for doing something that is not actually illegal. If it were illegal, then the courts would be legitimate. There's no crime, there's no victim. So that is this book. I don't remember how much I paid for it. I'll pay if it's a good book and it's got a lot of reviews and it looks like it's going to have some information in it. I'll pay $100 for a book. But this one is kind of small and it has really large print, so it's not that long, really. And so it's probably fairly inexpensive if you want to get it and read it. Pay close attention to the wording. And yeah, so more information on jurisdiction and the fact that a lot of courts don't actually have it.